Good evening. Today I'll be presenting on competence in the criminal process based on insights from the readings. We'll examine how psychological evaluations help courts determine whether a defendant is competent to make certain legal decisions, including consenting to searches, confessing, pleading guilty, and more. Competence in the criminal process goes beyond just being fit to stand trial. It focuses on decisional competence, which is the ability to make specific legal decisions, such as whether to waive one's rights or enter a guilty plea. This issue is important because the justice system values both fairness and autonomy. The courts must balance protecting vulnerable individuals with respecting their right to make choices, even unwise ones. We'll go into competence to consent to search and seizure. Much of criminal evidence comes from searches. Under the Fourth Amendment, searches must be reasonable and consent must be voluntary. But consent is only valid if the individual has the capacity to understand what they are agreeing to. For example, a defendant with intellectual disabilities or mental illness may not truly comprehend the consequences of granting consent, which raises questions about whether that search should be valid. Perhaps the most debated area is competence to confess. The Supreme Court has long recognized the dangers of coerced confessions, starting with Brown v. Mississippi in 1936. In this case, confessions extracted through torture were ruled inadmissible. Later on, the well-known Miranda v. Arizona established the now famous Miranda warnings. It requires police to inform suspects of their right to remain silent and their right to counsel. But even when warnings are given, defendants must knowingly, intelligently, and voluntarily waive those rights. Research shows that certain groups are at higher risk of false confessions. Juveniles, for example, often lack the maturity to fully understand their rights. Studies show that many under age 15 misunderstand at least one part of Miranda. Similarly, individuals with intellectual disabilities often want to please authority figures, making them more likely to comply with police questioning, even if it means confessing falsely. The risk also increases with long interrogations or when police use deceptive tactics, such as presenting false evidence or minimizing the seriousness of the charges. A critical case in this area is Colorado v. Connolly, 1986. Francis Connolly approached police officers and confessed to a murder. He later explained that he was compelled by voices from God to admit guilt. Despite clear evidence of severe mental illness, the Supreme Court ruled the confession admissible because the police had not coerced him. This case illustrates the court's stance that willingness to confess depends on police behavior, not the defendant's mental state. Mental illness alone is not enough to make a confession involuntary, unless police exploit it. This decision was controversial, as critics argue it allows unreliable confessions to be used in court. Over 90% of criminal cases are resolved through guilty pleas rather than trials. For a guilty plea to be valid, it must be entered knowingly, intelligently, and voluntarily. That means the defendant must understand the nature of the charges, the potential penalties, and the constitutional rights they are waiving, including the right to a trial and the right to confront witnesses. The case of Godinez v. Moran, 1993, raised important questions about competence. Richard Moran killed 3 people and later decided to represent himself, plead guilty, and refused to present mitigating evidence at sentencing, even though this meant he could face the death penalty. Psychiatrists found him competent to stand trial, and the court ruled that his same standard applied to pleading guilty. The court emphasized the autonomy. If Moran was competent to stand trial, he was also competent to make a guilty plea, even one leading to a death sentence. This case remains controversial because Moran was depressed on heavy medication and arguably unable to make a rational decision in his own best interest. Mental health professionals play a vital role in these cases. Their evaluations help judges determine whether defendants understand their rights, whether they are vulnerable to coercion, and whether their decisions are made knowingly and voluntarily. They also provide expert testimony on how psychological factors such as intellectual disability, suggestibility, or mental illness might affect the defendant's competence. Several tools have been developed to evaluate competence. Grisso's Miranda rights comprehension instruments are widely used to test whether a suspect truly understands their rights. More recently, Rogers and colleagues developed the Standardized Assessment of Miranda Abilities, a more comprehensive tool for adults. Beyond testing, reforms such as recording interrogations, simplifying Miranda warnings, and requiring legal counsel for juveniles have been recommended to reduce risk of false or coerced confessions. In conclusion, competence is central to ensuring fairness in the criminal process. Cases like Connolly and Godinez show how difficult it can be to balance respect for autonomy with protecting vulnerable defendants. Psychological evaluations are essential to this process, giving the courts the tools to determine whether legal decisions are valid and whether rights have been truly understood and waived. For this presentation, I drew on psychological evaluations for the courts by Melton and colleagues, along with research by Thomas Grisso, Richard Rogers, and Saul Casson, and colleagues on confessions and Miranda rights.